Assemblywoman Melendez.
Okay. I believe that Assemblywoman Melendez is coming next,
And then Assemblymember Cooley.
and then
Thank you.
Assemblymember Cooley and Assemblymember Lopez.
Thank you.
So item 31.
Thank you, Madam Chairwoman and members of the committee. And I want to thank Assemblyman Cooley, who was kind enough to let me go ahead of him as I have to get back to public safety on the assembly side to add my
was
votes. I
just
missed
there.
you there. I know, we were passing in the hallways. I apologize for that. Madam Chairwoman and members of the committee, I will start off by saying that I am accepting the amendments described in the analysis. Currently, sex offenders can be granted exclusion from the Megan's Law website if they are related to the victim. Every applicant that meets the requirements for the exemption will automatically be granted the exclusion. Those requirements are simply that they provide proof that they are completing probation and that they are related to the victim. While this exclusion was created to protect victim privacy, our state does not require any proof that this exclusion would be in the victim's best interest. We are allowing the exclusion of people who are committing sex crimes against their own children, stepchildren, grandchildren, without giving any thought whatsoever to the victim's consideration. The consequences of exclusions not only leaves children at risk for further abuse, but it can continue the victimization of sexually abused children. Young boys who are molested are 19% more likely to commit burglary, 25% more likely to commit armed robbery and grand theft, and 41% more likely to commit assault than other young boys who were not sexually assaulted. In order to prevent children from entering this cycle of prison and spending the rest of their life in an incarceration and in and out of the criminal justice system, I think we need to do our part to prevent these types of crimes from happening in the first place. This bill will modify the Megan's Law exemption for sex offenders who are related to their victim, ensuring that the exclusion is granted only when it is in the best interest of the victim. This bill has received bipartisan support, as well as support from Crime Victims United, California National Organization for Women Stand, For Families Free of Violence, United Advocates for Children and Families, California Alliance of Child and Family Services, as well as the City of Murrieta, which is in my district, the City of Richmond, which I believe is in the Chairwoman's district. Here to testify is Connie Valentine from California Protective Parents Association and Trevor Kelly from Incest Survivors Speakers Bureau of California. With that, members of the committee, I would respectfully ask for your aye vote.
Madam Chair, I'm prepared to move the bill at the appropriate time.
Okay, thank you.
Thank you. I'm Connie Valentine from California Protective Parents Association. Our organization seeks to ensure that children are safe from incest and family violence through research, education, and advocacy. This is surprisingly not easy. Family members commit about a third of child sex abuse. Nearly all are men who commit an average of 80 acts, which makes them serial offenders. Research shows that about 90% of children of divorce who report incest are not protected. We worked with Senator Batten in 2005 on SB 33 to remove the incest exception on sentencing. Now we find there's an incest exception for Megan's List. But incest betrayal is worse than any other kind of child sex abuse. It destroys a child. Along with about a third of the women in our country, I was sexually abused as a child. And the reason incest is worse than other types of child sex abuse is I ate dinner every night with my father, my abuser. I passed him the butter. He passed me the mashed potatoes. He smiled. The terror sank into my very bones. The abuse lasted for over a decade. It took 4 decades to recover. And the worst part was that I was used as a lure, as bait. If my father had been on Megan's List, perhaps my little friend Cynthia and my teenage neighbor Charlene would not have also had their lives destroyed. Today, convicted child sex abuser on Megan's List, Nicholas Elizondo, lives in Bakersfield in the custody of his young daughter, despite having served years in prison for sexually abusing his first daughter. He can petition to have his name removed from Megan's List. There would be no way for parents to know his status if his daughter invites her friends over to a sleepover. I urge your aye vote for AB 2569. Victims need to agree to remove this exception from Megan's List. Thank you very much.
Thank you. Others in support?
Hi, this is what I call the family member sex offender loophole. Good morning. I am Trevor Kelly. I'm an incest survivor. in recovery now for 26 years, and I am a recovered addict. I am the legislative director for Incest Survivors Speakers Bureau and a warrior in a suit. When the molestation started, it felt wrong and I hated it, but I couldn't stop my brother. He would say that if I tell, bad things would happen to me. I stayed quiet and died a little more each time. This taught me not to tell the truth, which reinforced my lack of credibility. If I did tell, nobody will believe me. It is here that seems to be where the exclusion process of Megan's Law fails children. This is unfortunate. In my case, this is where the sexual abuse started, but most definitely not where the sexual abuse ended. My brother started molesting my friends. At this point, the abuse became more severe. I started eating addictively to be ugly. Eventually, I started self-harm. Nobody noticed. Alcohol became accessible, and soon after, so did drugs, such as crack cocaine. I thought that was the best thing in my world. It got rid of the memories and the pain. My destiny was certain to be a heroin-addicted sex trafficking victim in Oakland, California. Luckily, I got into a rehab, and this is when the flashback started, doing perfectly fine until triggered, and it felt as if I were that little girl all again. I got counseling. I am left with an autoimmune disease because of the constant traumatic stress as I was growing. I have a mental illness due to this traumatic childhood. Finally, I started believing in myself. I put myself through college and have been married for 30 years. My progress is quite incredible. I have become a productive member of society and hope that through my walk, I create a path for others to recover and have a quality life. My goal: I come here today to tell the truth, my truth, in hopes that that little girl or little boy whose incest starts tonight can be protected from their own family. Public safety is important, but private safety is mandatory. Why are victims of incest not treated equal to other victims? I have not seen any information about the victims on Megan's Law. Why is there an excluded category to online registration for the family member sex offender? If the incest victim were your child's friend, wouldn't you want to know so you can protect your child and not send them for that sleepover? I need AB 2569 to pass because I need to know that something is being done to keep the taboo on the incest not in speaking about it. We must treat the incest survivor even more gently than the childhood sexual abuse victim. Recently, my best friend lost her daughter, an incest survivor, due to an untimely death, and her husband from a broken heart 30 days later because his father was the sex offender. And I respectfully request an I vote from all of you. Thank you.
Thank you. Others in support?
Thank you, Madam Chair and members. Dawn Kepke on behalf of Crime Victims United of California in very strong support.
Good afternoon, Ms. Chair. Kira Ross on behalf of the City of Murrieta in support.
Thank you. Are there speakers in opposition to the bill? If you could make room for them at the table, please. Thank you. You can proceed.
Thank you. Good afternoon, Madam.
Do it again, right?
Yeah.
There you go.
Thank you. Good afternoon, Madam Chairman, committee members. My name is Chance Oberstein. I am representing the California Reformed Sex Offender Laws, and also I'm an attorney in private practice who represents many clients who have been convicted of these laws, and they too have children, which I believe are the subject of this exception. The purpose of the exception, at least originally, was to protect children, to create protections for those children from public disclosure. Now, the collateral consequences of public disclosure often results in bullying, cyberbullying, and harassment and isolation. For instance, in high schools, in grammar schools, and in other places where children go. My concern with this particular bill is the timing of the exclusion. As I understand it, under AB 2569, there is a one-year waiting period before the exception can be granted. So as I understand it, the exception's not going away, it's just taking more time and there are more people involved. This is really analogous, at least in my practice, to asking permission to enter campus for those registrants who want to be involved in their children's activities. It is paramount in terms of disclosure that we are sensitive to the timing of the timing of permission coupled with the idea of public disclosure for that permission. Both permission and sensitivity to disclosure are part and parcel. If permission is granted but disclosure occurs, then even though the registrant gets permission to go to the function, the child then is at risk and threatened harm from the permission granted. This is very similar here, and it seems to me that by creating this 1-year waiting period, what you're doing is effectively eradicating this exception, at least the purpose of it, which is to protect the very victims of the abuse in the first place. So when you wait a year before it can be granted, what happens is that's open season for the type of horrendous harassment and bullying and harm that can occur to the children in these particular situations. That's why the exception was created in the first place. And that, in effect, would wipe out the exception completely, in my mind. So I would ask the committee to consider that, voting no, in terms of this modification of the exception.
Hello, my name again is Pam George. I'm here from the Alliance for Constitutional Sex Offense Laws, and I'm representing over 100,000 family members that are impacted by the registry and by the public Megan's Law website. I'm very sorry about what happened to the Assemblywoman's witnesses, but I do think it's important that the committee understand neither of their situations is covered by this bill, neither of them. I'd like to say that AB 2569 requires a local assistance center to speak to the victim before an exclusion exception is granted to a family member. But what criteria will the center use to determine if granting the exception is in the best interest of the victim? And what if the victim disagrees with the center, or is it simply up to the victim? And if so, what if he or she changes her mind? Will the victim be provided with written information regarding the lifetime, severe, documented, and sometimes fatal consequences for the entire family if a family member is on the public registry? And is it fair to ask a minor child to make that decision? Should the opinion of an advocate decide public safety and police power issues? None of these questions are addressed in this bill. Ultimately, the only way to protect a victim's privacy is to respect laws that protect her privacy and the privacy of her family. By empowering a local assistance center to strip an entire family, including the victim's siblings, of their constitutionally guaranteed privacy rights, AB 2569 terminates the enumerated privacy rights of law-abiding Americans. If you allow this bill to move forward, and it does become law, the Megan's Law website will finally be unmasked, and we will all have to face up to the fact that neither the website nor this bill are about the safety of children, because this exception is for the safety of the minor victim, a child. I would ask you to please vote no on AB 2569.
Okay. Are there other speakers in opposition to the bill?
Again, my name is Jean, mother of an incest survivor. This bill would do nothing to protect children, and I'm opposed to it.
Timothy Moore. I'm a member of a family who worked very hard at reunification, and it was made possible in part by this waiver. I oppose the bill.
Roger Honeycutt, business owner from Modesto, registered citizen, law-abiding citizen for over 25 years. I ask you to oppose the bill because sexually violent predators don't go back on the street. They stay in prison.
Frank Lindsay, Family Safety Foundation, strongly oppose the bill.
Mark Walsh, registrant for over 10 years, active in reentry policy in San Francisco, and strongly oppose this bill. I've worked in civil, constitutional, and human rights in these efforts, and mounting empirical evidence shows that registries do nothing to prevent recidivism or reoffense. I would strongly urge you to look at CDCR and your own case reports regarding these kinds of issues. Thank you.
Okay. Are there any questions or comments from members of the committee?
I would like to make a motion to move the bill.
Okay, the bill has been moved. Would you like to close?
Thank you, Madam Chairwoman and members of the committee. I'd like to address some of the comments that were made by some of the witnesses. There was a reference to that there's going to be this outpouring of harassment of the victims, and I don't know what that's based on. Other than pure conjecture. I don't know if there's any proof that would suggest that because this exception were to be put into place, that this would happen. So I just would urge you to not allow someone's opinion to sway your own on how you vote. The victim doesn't decide whether or not this exception is granted. This is the Department of Justice. The Department of Justice would conduct the interview and determine whether or not it's in the best interest of the child, and that is based on a number of different things. For instance, the offender may not even live near the victim any longer. So, is there harm to the child if they don't even live near one another anymore? Do they still live in the same home? There are all sorts of things that are considered before an exception is granted or denied. If for some reason it is denied, the offender can reapply 6 months later. This is not an absolute. I will also mention that the people who are conducting the interview, these are trained personnel. This isn't people they pull off the street and say, do you think you can determine if it's in the best interest of this child to have the offender on or off the list? That's not the case. Please, it's insulting for someone to suggest that it's so simple that we wouldn't have people who know exactly what questions to answer based on the age of the child and the maturity of the person that they are speaking with. It doesn't get rid of the exception. I want to stress that. Right now, someone can ask for an exemption. It's going to take them about 3 months probably to get that exception. It's not, one day they ask for it and the next day they're off of the list. It takes about 3 months. What we're asking for is a year, which I don't think is too much to ask for when you're talking about the safety of a child and other children. We hear many bills come through these committees where we're discussing the safety of women, the safety of children, the safety of victims. My goodness, you've heard those. Just today, I've sat and listened to them when you're talking about the Stanford rape case. So if we are truly a body that is out for the interest of the safety of victims, please, I would ask you to consider that when you're voting on this bill today. We're not increasing a penalty. We're asking for an appropriate amount of time to be put in place so that these victims are given the same consideration that we give others. Thank you, Madam Chair.
Okay, thank you. The bill has been moved. I'm actually going to do something I rarely do, which is stay off the bill today. And the reason really is, quite honestly, with 40 bills before us and trying to understand the nuances of many of them, this one goes so deep into psychological consequences for children that I am not comfortable with the kinds of testimony that we heard today, to tell you the truth. I think that cyberbullying is very alive and well. And it is, we haven't found a way to deal with that. The cruelty of children to children is pretty profound sometimes. And I can, who knows what would happen in a schoolyard or a high school if a victim were identified through the listing of a family member. These family members are the people we really have to make sure are contained, in my view. There's also the rights of the parents of other children to know who their kids are playing with. And I think that's a pretty profound right, too. If the bill moves forward today, I will certainly try to learn all of that. It moves forward to appropriations and see where we go with it. I'm just not able to vote for it right now with the level of knowledge that I have. So the bill's been moved. The secretary read the roll.
Hancock.
I'm not voting.
Anderson.
Aye.
Anderson, aye. Glazer. Leno. Lou. Monning. Stone. Stone, aye.
Okay.
Glazer, aye.
Glazer, aye.
Okay, we'll hold the roll open for the absent members.
Thank you, Madam Secretary.
Yeah.
Oh, Madam Chairwoman, I said Madam Secretary.
Well, we're used to various things here.
Okay. Assemblyman Cooley.
Assemblymember Cooley, yes. And it's item 23. Where are we? Thank you. Welcome to the committee. Yeah.
Madam Chair,
And we are going to adjourn after this bill at 12:30 because we're coming back at 1:30.
Recess and maybe take Ms. Lopez before.
Okay, after Ms. Lopez, who has been waiting patiently. Yes, okay. Thank you. Please
of
proceed.
course. Madam Chair and members, I am presenting AB 2327 regarding sentencing for luring minors for the purpose of trafficking them. I've had distributed something called a call to action from the Heat Institute. This is a large statewide project focused on commercial exploitation of children and human trafficking. My sponsor on this bill is Nancy O'Malley, District Attorney in Alameda County. She is chairing a Blue Ribbon Commission for the Heat Institute. They've been convening hearings around the state looking at best practices, how to work within communities statewide on human trafficking and commercial sexual exploitation of children. This bill is addressing a facet of the law which she identifies as a district attorney as of importance. As we know, almost 500,000 American youth are at risk for being sold for sex in the United States. In recent years, law enforcement has seen a growing use of the internet, the ability of people to connect with children on the internet, to lure them into destructive situations where they can be exploited, and as a consequence of which sexual assault can and does occur. Existing law outlines punishment for luring a minor with the intent of committing any of a number of crimes involving that minor, including kidnapping or rape, but does not include luring them for human trafficking. So this bill adds human trafficking to that list, for which it may be considered a crime to engage in contact with a minor. It will help law enforcement target traffickers more effectively. And I have with me Neil Layton, a Deputy District Attorney of Alameda County, who works with D.A. O'Malley to speak in support of the bill.
Thank you.
Thank you. Good afternoon, Madam Chair and members. I'm Neil Layton, Deputy District Attorney with the Alameda County Human Trafficking Unit, and here as a sponsor and on behalf of Nancy O'Malley, District Attorney of Alameda County. To be brief, this gives a necessary tool for law enforcement and prosecutors to use to attack the mindset of already existing law of criminals. Specifically, it allows for aggressive prosecutions of those who use the internet, and specifically social media is the main focus of what we see in the majority of our human trafficking cases, where minors are initially contacted and recruited by traffickers through things such as Instagram, Snapchat, and Facebook. This allows law enforcement to attack the problem initially and not wait for minors to be placed on the street or to be taken or kidnapped by traffickers and put on the street. It's the necessary tool that allows us to aggressively prosecute these crimes. And for those reasons, on behalf of Nancy O'Malley, we ask for an aye vote.
Okay. Are there others in support of the bill?
Madam Chair, members, Corey Salzillo on behalf of the California State Sheriff's Association in support.
Okay, thank you. Are there speakers in opposition to the bill?
Good afternoon. Micah Doctoroff on behalf of the ACLU of California here in respectful opposition to AB 2327. We share the Assembly members' important goal of protecting young people. However, we do not believe this bill is necessary to accomplish that goal. A person can already be convicted and punished for engaging in the conduct contemplated by this bill. Governor Brown has cautioned against creating new crimes that criminalize behavior already criminalized elsewhere in the penal code. And for these reasons, we share those concerns and respectfully oppose the bill.
Thank you. Others in opposition?
Move the bill.
The bill has been moved. Are there questions or comments from members of the committee? Seeing and hearing none, would you like to close?
I just request an aye vote. I think this is puts an important tool in the toolkit of prosecutors to protect kids. I thank you for your time and courtesy.
Thank you.
Hancock?
Aye.
Hancock, aye. Anderson? Glazer?
Aye.
Glazer, aye. Leno? Lou? Monning? Stone? Stone, aye.
Okay, we'll hold the roll open.
Thank
for
you
the
very much,
absent
Madam Chair and
members.
Senators.
Assembly Member Lopez, item 13.
Thank you, Madam. Good afternoon, Madam Chair and members. Today, I'm pleased to present AB 1909, which will increase the penalty in acting prosecutors to a felony that would hold evidence. Withholding evidence from a court case could be negatively impact someone's life and should not be handled lightly. AB 1909 will create a greater accountability for prosecutors with justice and system. Today with me, I have Ignacio Hernandez and testimony.
Thank you. Speakers in support.
Thank you, Madam Chair and members of the committee. Ignacio Hernandez on behalf of the California Attorneys for Criminal Justice. We are the sponsor of this measure. You know, for a number of years, we've been hearing stories of prosecutors withholding evidence. You know, the vast majority of prosecutors are doing their job well and following all the ethical rules, but we do have those pockets of stories of prosecutors withholding evidence, and as a result, individuals are wrongfully convicted and spending time in prison. I know that we've had, for example, Obie Anthony come testify here in the legislature on his story. He spent 17 years in state prison and was released about 3-4 years ago. His state claim is finally, I think, was just moved off the Senate floor just a few days ago. And one thing that we identified is that there really isn't an on-point penal code statute for prosecutors who withhold evidence. And so we think, even though hopefully it's a very rare instance, we have to ensure that there are some penalties on point for those prosecutors who intentionally and deliberately withhold evidence, so that we don't end up with wrongfully convicting individuals. So hopefully this statute is not used very often, but we do need it on the books as a deterrent, and also to ensure that those individuals who do choose to withhold evidence are penalized. We can't afford our system to be convicting the wrong individuals. So thank you if there are any questions, but we do ask for your support.
Thank you. Others in support? Are there speakers in opposition to the bill? The bill's been moved by Senator Glazer. Question from Senator Stone.
Thank you, Madam Chairwoman. I certainly support the bill. I think any district attorney that conceals, destroys, withholds evidence that wrongfully prosecutes somebody is terrible. But my question to you is, why aren't we holding defense attorneys to the same standard? I can tell you that in Riverside County, there was a public defender that was just fired for trying to manipulate an investigator's report on the accused. So if it's fair for the goose, it should be fair for the gander. And would the author be open to putting public defenders being held to the same standard?
Madam Chair, if I may respond to that. Okay, thank you.
Absolutely.
First of all, thank you for the support of the bill, and thank you for the question. It's been raised before. There are slightly different statutory requirements and ethical requirements for prosecutors versus defense attorneys. I think there are already on the books requirements for and penalties for defense attorneys to provide evidence within a certain period of time, and also, for example, certain evidence that's provided to defense attorneys, they can get in trouble, can be prosecuted if they turn it over to other individuals. So there are already some restrictions on defense attorneys, but where they are unequal is that prosecutors, as representatives of the people of the state of California, are under a slightly different obligation. Their obligation is not to vigorously win their case. And defense attorneys are supposed to be ethical, but they're supposed to defend their clients vigorously. So it's a little bit different. Prosecutors are, as representatives of the people of the state of California, are supposed to pursue the truth first and foremost. And so because of that, and because we give them so much responsibility and to pursue the truth and not just win a case, we think this bill makes sense. We certainly, as representing the Association of Criminal Defense Attorneys, we strongly frown upon defense attorneys that do not follow the law. So happy to look into the situation in your particular county, so the example you cited, and happy to discuss ways that we can address that. I know that our association does a lot of trainings and reaches out to individuals who may not follow the law, and we do not support that, obviously. So, but happy to look at that. But this was focused on those because DAs are just in a different position than defense attorneys. It's what we looked at. But sir, happy to look at that and see if there are ways going forward. Thank you, Senator.
Okay, thank you very much. Are there any other questions or comments? Did you move the bill, Senator? That's what I thought. Thank you very much. I'll be supporting the bill today, obviously. And thank you, Assemblywoman Lopez. You always bring us good bills.
Yeah. And just respectfully ask for your input.
Okay.
Hancock.
Aye.
Hancock, aye. Anderson. Glazer.
Aye.
Glazer, aye. Leno. Lou. Monning. Stone.
Aye.
Stone, aye.
Thank you.
Thank you. Thank you very much. The committee will stand in recess until 2 o'clock in room 115.
113.
113. Sorry, 113.
$17.62.